Good afternoon, sir. You're Trevor William Eugene Hewitt.
Yep.
You have two matters going on here, and we're going to deal with one of these to free up your probation agent, and then we'll address the preliminary examination. This is a probation violation petition. The defendant was placed on probation in January of 2023 on those two misdemeanor offenses. The allegation is that you violated your probation by violating a criminal law of any unit of government, failing to report on a monthly basis, failing to pay fines and costs, and failed to abstain from the use of alcohol and drugs or take a test on demand. And he also alleges that you failed to participate in treatment as directed. His recommendation.
Your Honor, I think we discussed, that was made a while back, and
Yes.
Per our discussion, I think I was just asking for time served because he has several days credit if you add them all up and just close the probation, revoke it at this point.
All right.
I think I have, since this original charge of 112 days, I think I have another 86 days, if my math's right, 65 in October and then 21 in August on other charges.
All right.
Related charges.
Mr. Hewitt, you have a new charge, which we're about to start addressing here in a few minutes. You're not on probation on that charge, but you're on bond. The earlier probation, because of other issues and previous violations, has resulted in 186 days in jail. Originally, he was recommending that I imposed a very large jail sentence, but he ended up doing a bunch of jail in the meantime. So your probation agent's recommendation, if you acknowledge that you got a new criminal charge or failed to report or failed to do treatment, he would simply recommend we revoke this probation and leave the new case to stand on its own merits. Do you understand?
Yes, Your Honor.
Now, Mr. George does not represent you on the probation violation. He's here with you on the other case. The original lawyer on the earlier cases was Mr. Gibson. In order to prove that you did violate your probation, we'd have to have a hearing, and you would be entitled to have an attorney where they'd have to show by a preponderance that you did violate your probation. However, you could also simply admit the violation, and there would be no need for a hearing. What would you like to do, Mr. Hewitt?
Well, I've already spoken to Dan, and the revocation and time served is probably what's best for me. I got a lot on my plate, as he mentioned. I got a case upstairs, and I got this case today. So
yes, you're on bond in circuit court, you're on bond in district court. And as far as what we're going to do as a probation, we've probably taken it as far as we can. So do you acknowledge that you failed to report and failed to complete your treatment as directed?
yes, Your Honor. I really would have liked to have gotten into the DV program, but it just hurdle after hurdle, and then I was in jail repeatedly. And like, I talked to Chelsea Myers about starting it, and she said don't start it because you got a lot going on right now, and if you start it and you don't complete it, then you only get one shot at it. So I never got to start it.
All right. You've already exceeded the statutory maximum on the domestic violence charge. The resisting and obstructing charge does carry up to a year or 186 days jail. Right at 186. I'll wipe out whatever financial obligations are left. Your probation is revoked. All right. Let's go on the record in the principal case set for today. In that matter, the defendant is charged with aggravated stalking. The allegation is that on October 4th of 2023 in the village of Constantine, that the defendant did engage in a willful course of conduct involving repeated or continuous harassment of Carly Harmon, the conduct being such that it would cause a reasonable person to feel intimidated, threatened, or harassed. Said conduct actually causing Carly Harmon to feel intimidated, threatened, or harassed. And at least one of the actions consulting in the offense was in violation of a restraining order the defendant had been on actual notice of. That is a felony punishable by up to 5 years imprisonment and a fine of up to $10,000 and a minimum probation of not less than 5 years. The defendant is also charged as a fourth habitual offender, making that, I believe, a offense punishable by up to life imprisonment. As Mr. Hewitt said in the previous record, he kept doing things to end up in jail. This matter was authorized by the prosecutor on November 29th and was signed by Chief Thayer of the Constantine Police Department on December 5th. The defendant was arraigned by Judge Pattison on December 12th. Judge Pattison adjourned the matter from December 12th to December 26th. On January 2nd, we were here and I made a record. The defendant was not here. There was a signed stip from the prosecutor to adjourn the preliminary examination until this date. Ms. Davis, what's the status here?
The people became aware of a bond violation today at the courthouse, and the corrections officer, Vincent Bailey, advised that after I spoke with Ms. Harmon, she walked outside. Mr. Hewitt decided to go out there with Ms. Harmon, or in the area of Ms. Harmon, and the corrections officers saw him communicating with her outside of the courthouse, which is a bond violation. He signed the bond conditions stating he would have no contact whatsoever with Carly Harmon. There are 2 other cases pending upstairs with her as the victim, and he has been in jail multiple times for these issues with having contact with her, threatening, intimidating. He's had significant mental health issues. And at this point, we're prepared to start the preliminary examination, but we would ask that the court deal with this bond violation first, such that Ms. Harmon is not very cooperative at this time, likely due, what we believe is to the continued contact with Mr. Hewitt. So I'd ask to have his bond canceled pending the outcome of the prelim. We can start the prelim today, but I would ask to continue it to another date so that I can speak with Ms. Harmon again.
Mr. George, what's your position?
Your Honor, we would be prepared to move forward today. We've reset this. I know the first time was because of my trial calendar up in circuit court, and I believe Officer Kuhn was unavailable for a period of time, and that's why we had adjourned it to today. My client's ready to get this going, get this over with. He's had this matter as well as the other 2 matters upstairs hanging over him. I know that I understand what Ms. Davis had just said. Obviously, I was not there. I didn't say anything myself. But what I would say is I know it does always put clients in an awkward position when there is some type of active bond condition or PPO in place and then they're in the same place. So I don't think that it's appropriate at this time to cancel my client's bond. I think an admonishment from the court would be sufficient. I think he's aware of what type of conduct is acceptable and what conduct is.
Well, he certainly is. And he told me as much. I'm going to continue to see her no matter what you say or do.
Afterwards, yeah.
What?
After this is all done and over with, I mean,
All right. Well,
it's going to be a long process, Your Honor, but I do plan on reconciling with her. I saw her outside, but I didn't talk to her.
all right. Well, don't say any more about it.
Yeah.
All right, stop. There may be video or something we could review. It would also be a violation of your 2 circuit court cases, but I don't have jurisdiction over those. And it just happened, so Ms. Davis hasn't had an opportunity to file any bond petition in the circuit court. Where we are right now is you're prepared to start the preliminary examination, but you're not clear whether you can complete it without the cooperation of Ms. Harmon. She's been hot and cold. So the question is, am I canceling a bond on a case that isn't going to get bound over? But let's go as far as we can here, and then I can make a decision on what to do with the bond.
Thank you, Your Honor. People will call Officer Max Kuhn. Officer Kuhn, where are you employed?
With the Village of Constantine, the Constantine Police Department.
And are you a police officer?
I'm a police officer. I've been employed there for almost 7 years.
And were you on duty on November 7th, 2023?
I believe so, yes.
And I guess going backwards, had you been made aware that Carly Harmon wanted to have police contact on or about October 4th, 2023?
Yes.
Tell me about that.
I received a dispatch complaint for regarding a welfare check, where the caller informed dispatch that he was concerned for Carly Harmon, or the caller was concerned for Carly Harmon. I arrived where I met with Carly Harmon and another male individual there. After speaking with her, they said everything was fine. And at that time, she informed me that she received multiple phone calls from a number that I don't recall the number off the top of my head, but she received multiple phone calls from a specific number. After speaking with Carly, did you have anything else further in the investigation? I had previous contact with her where I understood that Mr. Hewitt had a no contact or PPO violation. I received the number that she gave me from her telephone, and I contacted dispatch, and it matched the same number that she had received multiple times. And looking more into that while I was speaking with her at her apartment, she informed me that Mr. Hewitt was.
Your Honor, I would object as to any statements that she made at that time.
I'm not sure where he's going with this. I can maybe clarify the question. Were you standing with Miss Harmon at this moment that you're talking about?
Yes.
For getting a phone call?
Yes.
Okay. Did she receive a phone call while you were there?
I can't recall. I have to look at my report.
Based on what you found out from Ms. Harmon, did you go and speak with Trevor Hewitt?
At a later time, I did, yes.
Okay, was that on 11/7 of 23?
I believe it was.
Okay, and where was he when you had contact with him?
He was lodged at the St. Joseph County Jail.
And tell me about that contact.
When I met with him, he agreed to speak with me, and after reading his Miranda rights, I brought up the call that took place on October, and he informed me that it was him that was calling.
And so he admitted he was calling Carly Harmon?
He admitted that he called dispatch regarding the welfare check, and that phone number matched a phone number that Carly showed me that had called her multiple times.
And did you ask Mr. Hewitt about why he was calling?
I did.
Well, I'm a little confused. So was it Mr. Hewitt that called Central Dispatch and asked for the welfare check of Miss Harmon?
Yes.
All right. So he acknowledged that he made that call?
Yes.
Did he acknowledge that he called Miss Harmon?
Without reviewing my report, I can't say off the top of my head.
Your Honor, may he review his report?
Yes, he should have reviewed his report before he ever showed up here to testify.
Is your memory refreshed?
Yes, it is.
All right. And so what do you know about Mr. Hewitt's calls to Carly?
When I asked him if he had spoken to Miss Harmon, he mentioned that he speaks to her all the time.
And did you ask him to elaborate on that because there's this PPO?
Yes. He told me that he was going to always contact her and that he didn't give a fuck what the law says.
No further questions, sir.
Good afternoon, Officer Kuhn. How you doing?
Good afternoon.
You indicated that you served the PPO on Mr. Hewitt?
I served, I believe it was a PPO. There's a confusion between the PPO and bond conditions at the time, but yes, I served him, informing him that he was not allowed to see Miss Harmon, and I gave him a copy of the order.
Do you believe that that was a bond conditions for a criminal case, or do you believe that that was a PPO?
It was a separate incident. I'd have to look at that actual case to see exactly which one, but I believe it was a PPO.
Were you able to review the actual physical PPO itself?
At that time, prior to this event?
Prior to this case? Yeah.
Yes.
Okay. Do you know that if you were the one that served it?
I did serve it, yes.
Okay. All right. Just want to clear that up. So when you you met with Mr. Hewitt where? Where'd you
Prior
meet
to
with
this
him?
event, sir, or
In November.
in November at the St. Joseph County Jail?
Okay. Do you know what he was in custody for?
At that time, I don't know exactly why he was there. I know that he had an upcoming case that day that he mentioned.
Okay. Did he advise that he was represented by counsel in that case?
He did not. I did read him his Miranda rights, and he agreed to speak with me.
Okay. Were you able to check with jail staff to see what the circumstances of any case that he had at that time were?
I did not speak to them about any upcoming cases.
So you were just able to find out that he was in custody at the jail, is that right?
Correct.
And then interviewed him at the jail, is
Yes.
that right? Didn't really inquire about what the circumstances of his being in jail were, but read him his Miranda rights, is that right?
He was in custody, so yes, I read him his Miranda rights.
After November 7th, did you have any further contact with Mr. Hewitt?
No.
Okay. I don't have anything additional, Your Honor. Thank you.
Thank you, Officer Cohen. You can step down.
Thank you.
Do you have any other evidence to present at this time?
Not at this time, Your Honor.
All right, you're asking for an adjournment?
Your Honor, I would like the opportunity to speak with Ms. Harmon again when she has not had contact with the defendant.
She is here pursuant to a
She
subpoena?
was here pursuant to the subpoena. I don't know if she's still here or not.
Do we know whether she's still here? She left
Yes.
with your permission, or she just got mad and left?
Well, there was some confusion because we talked before, and then there was the bond violation, and then we did not get to speak after that
Bond violation in circuit court,
in this,
this case?
in the parking lot.
All right, well, so she was here today,
Yes.
and this was set at 1, so you saw her sometime during the lunch hour?
I saw her about 5 minutes to 1, I would say, and spoke with her.
All right, and then she left?
She went out, yes, Mr. Hewitt was in the hallway and I walked out with her. And then she went outside and Mr. Hewitt went inside. So, I mean, as an officer of the court, obviously I can tell you what I believe would be shown on the video and from the
Well,
statements, but
I'm not unwilling to continue it. The issue is he's gonna sit in jail if you get what you asked for in the meantime. I don't know how far you got with the witness. I guess your contention is that she was here ready to testify. Mr. Hewitt went out and talked to her and she left before you ever got a chance to speak to her.
that's not accurate. I did
Well, was
speak
she
with her.
willing to testify here today?
She was going to get on the stand if I asked her to get on the stand. And there was concern because of the hostility and her issues with contact. She was not in a good place today to be able to testify. And then with his behavior.
Well, I
after
wish she
I spoke
hadn't
with her.
left. I mean, she was here under subpoena and then she just drove away.
I think that there was, I guess, I don't know how much I can really get into on the record, but the concern was that she wasn't going to testify truthfully today because she was angry and had had contact with Mr. Hewitt.
Who was she angry at?
The system, her rights were terminated to her child.
I'm aware of that. So at this point, she's not particularly cooperative in any of these pending cases.
Correct.
She did get a personal protection order, and there were allegations of domestic assault. As you know, the defendant was on probation for domestic assault, and he acknowledged a domestic assault. Then she would continually reconcile, or I'm not sure what the right term is, his testimony as he got out of the hospital and went back and stayed at her house while the PPO was in effect and while bond conditions were in effect to prohibit contact.
No, there was no bond at the time, Your Honor.
All right, correct. Then that may be accurate. Then that resulted in some of the other charges. She did testify at least one previous preliminary examination. I'm not unwilling to grant you a continuance. The question is, do I cancel his bond? I guess I want to know what happened.
Your Honor, the video shows me walking Ms. Harmon out past security. Mr. Hewitt was in the hallway at that time, seated. And after she walked out, and I stood there for a moment to make sure she made it outside without being bothered by Mr. Hewitt.
Why did you walk her out?
Because Mr. Hewitt was sitting in the hallway staring at
Well,
her.
why didn't we put her back in your office or something?
Your Honor, she did not want to cooperate, and it seemed very clear that it was based on her continued contact from Mr. Hewitt. I knew I wasn't going to get anywhere with her at this point, and I needed to talk to Officer Kuhn, who was in the back. Not even a minute from when I stepped away from the security desk, Mr. Hewitt went outside the same way that Ms. Harmon had gone. And on the video, there's two separate videos from the angle. He was speaking with her, and Corrections Officer Bailey went out there and saw them having communication, although they were standing probably 10 feet apart, perhaps trying to look like they're not having communication. So at this point, he has contributed to the unavailability and hostility of this witness, which is the key witness in all of his cases. And the testimony that has been provided thus far in this case, probable cause purposes, maybe it's enough to bind over. Was it threatening, intimidating, harassing behavior? We don't have her here to say that today at this point, but it was a direct violation. It was knowingly a violation by Mr. Hewitt. And he's so brazen to do it today while we're all here at the same courthouse. I don't know what else to do. If the court's not going to bind it over without her testimony here, then I would ask to
Well,
have some
all right,
time.
there's enough probable cause from the testimony of Officer Kuhn to believe that he violated the restraining order. I'm troubled in that she was never going to testify today regardless of what happened, because she had already been released, or I'm not sure, but she was leaving. She wasn't going to come in here. I was going to have an opportunity to speak to her. So she never was going to testify. And I'm embarrassed that they were able to have contact with each other out in the hallway.
It wasn't in the hallway, it was outside.
No, I believe you said he was sitting there staring at her in the hallway.
Yes, he was.
Well, that,
As you're aware, there is a window into our waiting room
oh,
that has a
okay, so
direct
she
value.
was in your waiting.
She was in our waiting room,
Oh,
yes.
all right. Well, that's better. And then at some point she got up and walked out of your waiting room?
Met with her back in my office and we discussed the case and what's going on. And she then walked out and I saw him still sitting there. And so I walked with her out past security and waited until she walked outside. And then I walked back in to go talk to Officer Kuhn. And within 2 minutes, Corrections Officer Bailey was coming in saying, you need to know that they're having contact outside.
Officer Bailey, would you come up to the podium, please? Good afternoon. Would you state your name, please?
Vincent Bailey, sir.
Please raise your right hand. Swear affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief.
I do.
Officer Bailey, you are a sworn deputy assigned to a bailiff duty in this court, is that correct?
Yes, sir.
And other courts here in the courthouse. You've been present when Ms. Davis was relating to the court what happened. Did you see the defendant follow the witness, Carly Harmon, out into the parking lot?
I did, sir.
All right, tell me what you did.
I was actually coming in from bringing some individuals from the jail to here. When I came in, I was given instruction to go and find, I'm sorry, I forgot your last name.
Ms. Davis.
Ms. Davis, because there was notice of those two conversating through the cameras. So I went to find her to let her know what I was instructed to pass on.
So did you actually see them talking out in the parking lot or just saw it through the camera?
Once I made contact with her and we walked outside, the individuals were roughly 10 feet apart diagonally. Did I see them verbalizing at that particular moment? No, but I did view the footage and you can see Ms. Harmon? Ms. Harmon, where she was standing, you could see her verbalizing, but she was standing by herself. Then you have to look at the other camera angle. And the only person she could have possibly been talking to would have been Mr. Hewitt.
All right, thank you. Mr. George, what's your position? I guess a couple issues. Are you moving to bind based on the testimony you have? Or are you asking to continue the matter? And then if so, well, yes, I'll ask that.
Your Honor, I'm asking to continue the matter so that I can speak with Ms. Harmon and hopefully secure her attendance at a future hearing.
All right, Mr. George.
Thank you, Your Honor. Well, I did have the opportunity to review the video. Obviously, there's no sound. There are two different cameras and you can see the two individuals outside on the same side of the building. You know, in viewing the video, one of the things that I'm having trouble with is Ms. Davis had indicated that it's my client that is causing her to not want to cooperate, not want to be here. But, and maybe I viewed it once, so please afford me a little bit on that. But from what I understand, she's outside, she's smoking a cigarette, and she's texting, and then it ends once she gets picked up by a vehicle. Obviously, that wasn't driven by my client, so it looks to me like she was leaving. So, you know, I think that, you know, my argument would be, I don't think there's been anything that's established that my client was doing anything to try to prevent her from testifying today. I think that we need to have a hearing and probably need to hear from Ms. Harmon if we're going to take the step of taking my client's liberty away and putting him in custody until we have the second part of this preliminary examination.
All right, let's do a little history lesson. Mr. Hewitt was charged with resisting and obstructing police officers and domestic violence. That incident alleged to have occurred on October 4th of 2022, and he was charged at that time as a fourth habitual offender. That is the case that the defendant was on probation on, that was the subject of probation violation hearing earlier. The defendant did 186 days of total jail in that case. He entered a plea to attempting to resist or obstruct a police officer and assaulting Carly Harmon. He was placed on a probation, which included a number of things, including no contact with Carly Harmon. And a record was made earlier today where that probation was revoked. Next in line is a aggravated stalking case and fourth habitual offender alleged to have occurred in August of 2023 in the village of Constantine. We had a preliminary examination on November 7th, and there was an issue about who or when the probation officer, when the PPO was served.
Oh, you probably shouldn't have showed up.
Good afternoon, Mr. Hewitt.
Good afternoon, Your Honor.
You're here today for a preliminary examination on a charge of aggravated stalking. It is alleged that in August of 2023, you did engage in a willful course of conduct involving repeated or continuous harassment of Carly May Harmon. I don't know if that was directed at Miss Harmon or who it was directed at. I don't want you to say one word to her, or I'm going to have you taken back to the jail, and we will do this by Zoom. I got your letter, which I shared with your lawyer and the prosecutor, so they have received it as well.
Sure, the people call Carly Harmon to the stand. At some point, did you take out a PPO against him?
Yes.
You recall when?
August, before August,
So either
at the beginning of August.
beginning of August. And so after the PPO, after you filed for the PPO, did you have some contact with Mr. Hewitt?
Yes.
Yes. Could you describe, I guess, explain to me what that contact was exactly?
Well, let's see if we can nail this down. This is alleged to have occurred on August 14th. Do we know when the PPO was filed?
According to Lean, served on the 27th of July.
You accept that, Mr. Gibson?
Sure, certain constantly. I'm not sure the date.
Was it done by law enforcement?
Done by, this guy. Next thing, Constantine Police Department. We just visited me today in jail.
Just had my dog with me. Well, Your Honor, I would leave that. I guess my client's not willing to make any kind of stipulation about that.
Mr. Hewitt, you indicated, I could hear your discussion. Officer Kuhn visited you at the jail today?
Yes, he did, Your Honor.
For what purpose?
I was in the behavioral health of Bronson Behavioral Health in Battle Creek. And while I was there, I was calling Carly. And
No, but why was Officer Kuhn there
that is why
today?
he was there.
To ask you about,
About phone calls made from Bronson Behavioral Health.
while you're represented by two separate attorneys?
No, I don't know. What do you mean?
Well,
He was just asking about alleged phone calls that were made to Carly because there was a welfare check done at Carly's apartment that I called for. Because she wasn't answering the phone and I was.
all right, don't say any more about it. You've got an attorney in this case and an attorney in your next case.
I thought it was the same. Paul represents me in both cases.
All right, and have a concern, and your lawyer may have a concern that the Constantine Police Department is questioning his client while he is being represented in these two cases.
I didn't get to talk to him about that yet, Your Honor.
All right, well, it just came out inadvertently. Mr. Johnson will deal with that with the police. Chief Thayer isn't here.
His name is
All right.
Deputy Max Coon.
Yes, okay. All right, let's back up. Do you have the other PPO here?
I've just, what I've got I've just got the lien paperwork, Judge. I don't have a copy of the PPO.
We didn't really discuss it.
All right, don't say anything else. Would you go call Tiffany and we'll confirm this? All right, so we'll find out what date the PPO was served. Right now, it's not clear. We'll get the court record and confirm it. But assuming it was served sometime prior to August 14th, continue your questioning.
Okay. So we were talking about contact you may have had with Mr. Hewitt. I guess, did you have contact with him during this time frame around August 14th?
Other than him being at my apartment.
Okay, so he was at your apartment sometime around then. Was there any other contact you had with him during that general time frame? No. Did he contact you?
Yes.
Yes. How did he contact you?
The jail phone
Okay, so you got a phone call,
or multiple.
multiple phone calls. You know about how many phone calls you received?
I think I saw the paperwork that the call log, there was 120, give or take.
And so 120 phone calls in about what period of time?
About 3 weeks. Yes.
Okay. Did you answer any of those phone calls?
I had other people answer them for me to tell him not to call anymore.
Okay. So did you ever speak with him on the phone during those times?
Maybe once.
Okay, so you might have answered one of those calls. Do you recall what the conversation was about? Or how long you spoke with him?
Just him asking for forgiveness. About 2 minutes.
Did you receive any other communications from Mr. Hewitt during that time frame in August of 2023?
I received a couple postcards.
Were they addressed to you?
Well, it was at a different name, but I know it was for me.
Okay. And I guess, how did you know it was for you?
I had my middle name and his last name.
I've got what I'm going to mark as people's one. I'm going to show you here.
Depth of the cowboy boots.
Yeah.
That. I guess, I just handed you a copy of something. Could you tell me what I just handed you? Do those look familiar to you?
Yeah, these are the postcards.
Those copies of the postcards that were sent to you? All right. So I'd move to admit those copies as people's one.
All right, Carly, could you we've got both exhibits marked as number one, and that's not gonna be real good. Do you remember which one you got first?
I think the one with the duck was the first one.
Would you read it?
Dear Moon, I've been thinking of what to write to convince you of the fact that I appreciate, respect, and am grateful for you being in my life. I care about you and how you feel. It all comes down to proof, and I have not been proving it. What it all amounts to is love, and the scales have been tipped in a big way. In your way, I owe you more than I can repay. What I mean to say is that you have proved your love to me, and it's big love for sure. If I lose you forever, I cannot live with myself, because life without it wouldn't be worth living alone. You're still my best friend and the best lover ever. Without you, I am nothing. You're the best part of me. I love you.
On that?
This one, no.
All right, would you hand me that one? We're gonna mark that one as
Gonna
exhibit.
do
You
them
have it.
separately.
That will be exhibit number 1. And the second one, we'll mark that as exhibit 2. That's got a flower on it. Could you read that one?
Dear May, I'm writing this to beg for your forgiveness. I know I've made a lot of mistakes and regrets to you. I have tons of regrets and wish I could take them back with hopes of making it up somehow. I don't know how to yet, but I hope there is a way. I'm begging for your friendship. I know we're so distant that everything may be impossible. I only ask that you don't let them win all the way. They already took our son from us and now they want to put me away for what seems like forever. Please don't let them. If you ever cared about me, please have my back like you used to. Remember all the good and leave out all the rest. Remember all the good. You were my best friend and I knew you know me better than the rest ever will. I beg you not to give up on me and to please stay in touch. I'm sorry for not being a better man for you. You deserve so much more.
All right, so these were received in September. Oh, one is received September 5th, and the other one, I can't see the date. So were these after the personal protection order was filed?
Yes.
All right, we got I still don't, once upon a time, we had a paper file. I could get the file and you should have it. But the petition was filed on July 11th. The clerk filed a proof of service that they served it on the sheriff on July 11th, but I still don't know when the sheriff served it on the defendant. He's not bound by it until then, so we'll have to, never mind. We may have to wait till we get Deputy Thayer here. All right, Mr. Gibson.
So you said that you considered those harassing, those phone calls. Did you actually suffer emotional distress as a result of the phone calls?
They were all, most of them were ended up being blocked, so I didn't even notice they were coming in.
Well, I understand you say that it was harassing, but did it cause you to suffer any emotional distress?
Yes.
Can you describe the emotional distress that you were feeling?
Distressful and hurt because I did care a lot for him and knew it was all bad, so I knew it was all going to end bad.
Did you want contact from Trevor Hewitt?
No.
At the time that Trevor Hewitt was in jail, had you provided money to his account at the jail so he would have the ability to make phone calls?
I think the very first time before the PPO violations one, I did put money on his phone for him to contact his dad.
So you mean you put money on his account at the jail?
Yes.
After you got the PPO, did you provide any additional money to Trevor Hewitt's account at the jail?
No.
Mr. Hewitt, just try to remain quiet. If you want to tell your lawyer something, you can write it on.
I can just say it.
No, you can't say it. I want you to stay quiet.
She recorded to the jail. Every single phone call is recorded. It says it'll be recorded before you accept a phone call. So she's lying.
If you did answer one of the calls and talk to the person on the other end of the phone that's from the correctional facility, is it your understanding that that phone call would be recorded?
Yes.
Listening to her say that she loves me. Yes, totally, man. Is it too late to represent myself, Your Honor?
Yes,
I have no further questions.
thank you. Ms. Harmon, you can step down.
Am I gonna have a chance to take the stand today, Your Honor?
I suppose rarely does a defendant take the stand at a preliminary examination because anything you say can be used against you. I can't prevent you from testifying at a preliminary examination.
I just want my chance to talk.
All right.
It's,
All right, well, it'll come at some point, but should not be today.
if I'm going to prison for this, Your Honor, and.
But you're not doing yourself any favors. You're making it worse.
Your Honor,
Tuesday at 1 o'clock.
if I may just add one thing, it seems to me that we should at least have a copy of the personal protection order or whatever restraining order they're gonna rely on?
Yes, it's a matter of public record. You should have gone to the clerk's office and got a copy for yourself. It isn't a matter of discovery. Go get one. It's a public record.
Yeah, I know I received the PPO that said that I wasn't allowed to contact her at all. You know, she went to work and I was in her apartment. I was there. for-
All right, don't say any more about it. And I had to go on a scavenger hunt to get it, and it should have, but once upon a time, it was a real file. They're also hard to get remotely.
Your Honor, you had mentioned last Tuesday that bond would be addressed today. I'm really hoping that you can.
No, well, we'll address that also. I'm not inclined to alter the bond. I think you're dangerous and scary, and you're delusional in your attachment to Miss Harmon, who does not want.
No, I
any
can let her
contact
go,
with
man.
Officer Thayer, would you come up to the witness box?
Chief Thayer, who's your employer?
Village of Constantine,
What's your position with the Village of Constantine?
police chief.
Were you working on August 12th?
Yes,
Did you have contact with a Carly Harmon that day?
I did.
What was the nature of that contact?
I was dispatched there to check on a dog that had been locked in a car out in the heat.
Were you able to determine where the individual in the vehicle might be?
Yes, the manager suggested it, directed me to apartment 14 just because the tenant was fairly new and it could have been them. And so I checked there and discovered Mr. Hewitt had admitted it was his dog and the car was under his possession at that time.
Was there anybody else at that apartment?
Ms. Harmon, the tenant.
I guess, did you investigate further into the situation at that point in time?
I asked him to go out to the car with me so that we could get the dog out and then began asking for his name and whatnot, and actually received a false name from him.
Objection, Your Honor. I'm gonna object to this line of questioning because it calls for hearsay.
Objections overruled. It's a statement of the defendant, and that's not hearsay, it's an admission.
So he gave you a different name.
Correct.
How'd you determine that name was incorrect?
Well, it was obvious that he was drawing from creation to figure out his name and his birthday. It was clear that he didn't readily know it. And so I ended up securing him in the back of my patrol car and then going to talk to Ms. Harmon that I hadn't had a chance to talk to yet. And she gave me his correct name.
Did you run Mr. Hewitt through lean at that point?
I did.
Did you learn anything relevant to the situation at that point in time?
First off, confirmed his identity through his driver's license image, but then secondly, discovered a personal protection order that had been served on July 27th.
Thank you. That's all I have.
Mr. Gibson,
I don't have any questions.
any other testimony?
None, Your Honor.
Mr. Gibson?
The defense would call Carly Harmon.
Mr. Gibson, she was already subjected to examination and cross-examination. What else do you wish to ask her?
What was, the officer had testified that Trevor Hewitt was saying that he had been invited over to her residence that day. So I wanted to ask her about that.
All right, Mr. Gibson.
Did you invite Trevor Hewitt over to your residence that day?
I'm going to object as to relevance. The matter of whether he was invited is not material to the violation of the PPO that's being discussed here.
That is accurate. It's not her order. It was Judge Patterson's order. So to some extent, it doesn't matter whether he was invited or not, but I'll allow you to answer the question.
I don't know what he asked me.
Did you invite Trevor over there that day?
No.
All right. You can step down.
Okay, I have no further questions. The defense doesn't have any other witnesses.
Motion to bind,
Yes, Your Honor. We move to bind this over.
Mr. Gibson.
The defense would wish to point out that when it comes to this type of a situation, the conduct that is alleged to have been prohibited conduct in the personal protection order, that needs to be related to the conduct that is alleged. In this circumstance, the defense would leave this in the court's discretion. Thank you.
Can I have a chance to talk, Your Honor?
No. I'm not, you just don't. That's just how it works. That you don't just get to, but this is a probable cause hearing, as I stated. The charge is alleged to be aggravated stalking. Nobody ever put their order in effect. I mean, I have it, but it's not in evidence. But Chief Thayer testified that the order clearly said he was not to have any contact with her. So there is sufficient evidence. And again, Mr. Hewitt, I stress this is a probable cause standard. Probable cause to believe that a crime was committed and probable cause to believe that you did it. So I'm going to bind the matter over as requested by the prosecution. On that day, it was established the defendant had been served with a personal protection order. The matter was bound over to the circuit court. Bond was $5,000 cash or surety and had not at that time been posted. I believe once the defendant was bound over to circuit court, at some time that bond was posted. Now, bear in mind, the incident in that case is alleged to have occurred on August 14th of 23. There was another felony case, 231828. In that case, it was a domestic violence case, charged as a third offense, and that allegedly occurred on July 6th of 23 in the city of Sturgis. And we were dealing with that on October 31st. It was a plea offer. Defendant declined. We set the prelim in the domestic violence case for November 14th. All right, the next case, it's alleged that on or about July 6th, 2023, in the city of Sturgis, that Trevor William Eugene Hewitt did make an assault on Carly Harmon, an individual with whom he had a dating relationship. That's called domestic violence or domestic assault. That's a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. But your charge is being a second or subsequent offense, which turns it into a felony as a fourth habitual offender, which further endorses it, I believe, up to a life offense. And so we're going to take testimony regarding this alleged domestic violence of July 6th. Mr. Johnson, are you ready to proceed?
Yes, Your Honor.
Mr. Gibson?
Yes, Your Honor.
All right, you may call your witness.
The people will call Carly Harmon back to the stand. Ms. Harmon, do you recall where you were on July 6th of 2023?
I believe I was in Sturgis.
Did you have contact with Trevor Hewitt on that day?
Yeah, we were supposed to have court for our son.
And what's your relationship to Trevor Hewitt?
Oh, yeah, we were together.
You like in a dating relationship? Okay. What was the nature of your interaction with him on the 6th of July?
Well, we had both had court for our son, so we were both all super upset because things weren't going well. Our like talking argument kind of escalated.
Did it get physical?
Yeah, he grabbed my arm, but
You recall what the disagreement was about?
the vehicle.
I'm showing defense counsel, but I'm going to show you what I've marked as people's proposed one. There, you take a look at that. You tell me, do you recognize what's in the photo there?
Yeah, it's my arm.
Sure. Is that your arm on the date of this incident?
Yes.
Yeah. That what it looked like following the exchange you had with Mr. Hewitt? Okay. And this little redness here is from the contact you had with him? Is that correct? All right. I would move to admit people's one, and I have no additional questions.
Mr. Gibson, any questions regarding the exhibit and or the witness?
If I may, dear the witness
Certainly.
about the exhibit,
Yes.
do you specifically remember this photograph being taken?
Yes.
Okay, and so you remember that this would have been the clothing that you would have been wearing that day?
Yes.
Because I was at work the entire day from 8 o'clock in the morning till 6 at night, and this happened at 2 o'clock. I wasn't there. That's what it matters.
All right, that's not evidence or testimony, it's the
So-
defendant's position.
The day that this happened, do you recall if you knew that Trevor Hewitt had a job at that point in time?
Probably, yeah.
Do you know where he was working at that time?
The fire mechanic place.
So if this happened at around 10:07 in the morning, wouldn't Trevor have normally been at work at that time of the day?
Not if he had court, I would. But yeah,
Okay,
Jeff will testify. Jeff will testify that I'll.
all right, thank you. I have no further questions.
So was this before you would go to court or after?
It was at 9 o'clock in the morning at court via Zoom
Okay, so did this incident happen after that?
after.
All right, happened after the court hearing. All right, and the hearing was via Zoom. Was Trevor also at the hearing via Zoom?
Nope, he did not attend.
You indicated there was some struggle about a vehicle.
Yeah,
So did he come to get this vehicle?
yeah,
Was there a dispute about that?
yes,
Did he end up taking it?
yes.
All right. Does that raise questions for anyone else?
No, Your Honor.
All right, you can, Mr. Gibson, any for you?
Do you know how Trevor would have gotten there that day?
Yes,
Could he have walked?
I guess.
Okay, because he didn't come in the vehicle, I assume, if it was at
Maybe,
that
well,
residence.
his boss was giving him rides back and forth to work, I'd assume.
So you're just not sure, you're not
I
certain
had
how he
bigger
got there?
things to worry about than how Trevor was getting around at that time.
Okay, thank you.
All right, you can step down, thank you. Anything further?
No, Your Honor, no further.
Motion?
Your Honor, move to court bind over on count one.
Mr. Gibson?
The defense will leave it in the court's discretion.
Mr. Hewitt, that doesn't mean he's rolling over and playing dead. He just knows that the standard is pretty low. And essentially, this is a misdemeanor, impermissive touching of someone you're in a dating relationship with. She testified that you grabbed her arm. There was an argument about the car. I can see the marks. That's an
No, I wasn't-
impermissive touching.
I
She
wasn't
says you
there.
were dating and you had a child. Well, that's called an alibi defense, which you present a notice of intent to provide alibi, and there's a way to do it, and you can pursue that in the circuit court. I wasn't there could be a pretty good defense if in fact you weren't there. There was some confusion about what day this was, but the complaint alleges it's July 6th. Anyway, because you have two previous convictions for domestic violence, which the court takes notice of from the complaint.
That's very serious, Your Honor.
Well, it
Very,
is,
very,
it turns it
very
into a serious 5-year felony offense as a habitual. So I agree with you there, Mr. Hewitt. And
With a life tale, Your Honor. This is something that I never would ever plan for in my life. This is something that is crazy to me. Judge
Well-
Middleton, you, man, I've been talking to you and seeing you since I was 13 years old.
yes, sir.
This is insane.
Well,
This right here this is crazy.
I
never-
wasn't there and I never am there.
I know.
And if I ever was there, I couldn't hear the case. So it's a standard of probable cause. But
I had
this matter is so sad, as you testify here, it involves your son. This relationship has,
has tormented me in a humongous way. I still love her. I
yes,
still love her.
and you
And I know
can't,
she still loves
you
me.
can't put it down. But I
I
find that,
can't put it down. She won't let me put it down.
Well-
She won't. As long as she won't leave me alone, I'm never gonna leave her alone.
well, you
And that's
didn't need
what
to call her
When you ask
120
her,
times from the jail, but
we were supposed to get married in your court, Your Honor.
I understand.
You remember that?
Yes, I do. All right, you can take Mr. Hewitt out. Both of these matters are bound over to the circuit court. Bond remains as scheduled. And we'll deal with it upstairs. Good luck.
question is, do you still love me?
Mr. Hewitt, you have a
You do.
personal protection order. You're not supposed to even have
No
any
matter how long I
contact.
do in prison. It doesn't matter if I do 10 years in
Well,
prison.
you're working
As long as you're
yourself
still waiting for me when I get out, I'll still marry you.
into it. All right. He's gonna remain in custody pending a disposition of these and other cases. And Ms. Harmon did testify, and the defendant was bound over on November 14th. The incident in this case was October 4th. The defendant was bound over on November 14th. So we had a domestic violence that allegedly occurred in Sturgis on July 6th. It took some time to get that matter to court. That prelim was held on November 14th, and the defendant was bound over to the circuit court. In the next incident in time was the August 14th incident of stalking. Preliminary examination was held in that matter. Ms. Harmon testified the defendant was bound over to the circuit court on November 14th. The next incident in time is this incident, which October 4th. Officer Kuhn went to the sheriff's department to talk to Mr. Hewitt, according to the affidavit, on November 7th. And then he submitted it for a warrant on November 29th. So the prelim had been held on November 14th. This got submitted to the court in early December. And I would note in every one of these cases that I've mentioned, he has a no contact provision as part of his probation. He has a no contact provision with Carly Harmon as a part of the domestic violence case. He has a no contact provision from the stalking complaint of August 14th, and he has a no contact condition in effect from the incident of August 4th. So the matter was bound over after preliminary examination on those two cases on November 14th. We took testimony, I recall it. Very close time after that, there was a hearing in the family court, in which case Ms. Harmon lost custody of her child. In fact, lost parental rights, in part because of all of this. And so did Mr. Hewitt. That's as hard as it gets. Then this case got adjourned a couple of times, and the indication would be as of October 4th, he was violating the conditions of his bond and his probation. And as of today, he was violating the conditions of 2 circuit court bonds, 1 district court bond, and 1 district court probation. And the defendant is bound and determined to have a relationship with Ms. Harmon. I don't know which side of the line she's on at this point, but the court looks pretty foolish when we keep ordering not to have any contact from a personal protection order, from a probation order, from a bond in a stalking case, from a bond in a felony domestic violence 3rd case, and this new stalking case from October 4th.
Your Honor, can I speak?
No, I'm offended by that. It makes us look foolish. But I'm also offended by bullying you into some sort of a plea by locking you up, because I don't think she's going to cooperate 2 weeks from now any more than she did now. But I also believe there's probable cause to support a bind over based on the testimony that I heard today. Mr. George, if you want your client to speak, I'll hear him. If you want him to not, I'll defer to anything else you have to say.
Can't help but look at it from her perspective, with everything going on. Yeah. I hate that she's going through what she's going through. I hate it. I did want to say something. Can I just, Your Honor, when I spoke to David Tomlinson, he said that I was awarded a visit with my son. And if I made bond, that I would have a visit with my son. I've been in contact with Heather yesterday, and I have to talk to Chelsea Myers about doing a scrapbook for my son and possibly seeing him one last time before he goes up for adoption. And I just want to say, if my bond is canceled, I can't do that. And I'll be right down the street, and I'd actually have an opportunity to get to see my son. Maybe take some pictures of me and him for the scrapbook. It's really big. Even though they say he's been gone so long that it would be pointless of me seeing him, I still want to see him. I don't think that's a good reason that he's been gone too long. To hug my son would be really awesome.
I didn't review the record of the family court case, but I do believe that your rights were terminated because you failed to comply with all these bond conditions and personal protection orders. There are multiple allegations that you were assaulting her, and she declined to stop contact with you, which resulted in the termination of your parental rights.
Yeah.
That's about as sad as it gets. So I'm going to continue this preliminary examination until January 30th. Bond is canceled.
Do what?
It's canceled. You're going to jail.
Why?
I
Wait,
don't want
what?
to argue about it. I'm not happy about it either.
It doesn't help anybody though.
No, it doesn't.
It doesn't help me at all. Your Honor, please.
Please remove the defendant from here.
Oh,
I don't want to argue
I
about
got a
it.
backpack over here.
Might be not gonna cause me a problem right now. I know.
No, not.
Thank you, Your Honor.
Your Honor, is there,
Do it.
please, is there a
Come on,
chance?
we gotta go.
The answer is no.
She got my attention out there, man, and
Yeah,
You
what
I
am I
just,
supposed to do?
I just got your attention also.
Trevor. You don't want him to add one
I'm
month.
trying to dig a hole, man. I'm just trying to stay out of jail and see my son.
He has dug a hole. Ms. Davis, if you're serious about this, you'll be filing petitions to revoke his bond in the circuit court. You may have gotten to the point where, what else do you do? She wants to, although they took her child away and his child also. And not sure that any order of the court is going to keep them apart. Mr. O'Bear, in one of the earlier proceedings, had proposed a global plea agreement to resolve everything.
Yes, Your Honor.
At that point, the defendant was unwilling to agree with that. We'll address this further on January 30th at 1 p.m.
Thank you, Your Honor.
Thank you.